Well, hello everybody again, and welcome back. Hopefully you were able to get a cup of tea. Usually we have a chat, don't we, around the coffee point when we're meeting in face to face, but obviously it's an exceptional times at the minute. So we're going to carry on now with plant protection products, and we've actually got a panel of three for this one to break it up. So we're going to start with Sam from DEFRA, and then Rachel from HSE. And then Julian on MRL. So I'll hand over to Sam to start.
Thanks, Matt. Hello everyone. My name's Sam Phillips. I'm part of DEFRA's pesticides policy team, and I'm here to cover some of the more kind of big picture changes that we've got on the horizon for pesticides. And then I'm going to hand over to Rachel Brown from the HSE to look at some of the more sort of detailed technical changes that you need to be aware of. Okay, so as we've already heard, the transition period is coming to an end on the 31st of December. And from the 1st of January, we'll be operating a new independent pesticides regime in Great Britain. So all of the current EU pesticide legislation is essentially being carried over into national law, with only sort of minor changes really to ensure that it continues to operate sensibly in a national context once we're outside of the EU. So this includes Regulation 1107/2009, which regulates the placing of PPPs on the market, and Regulation 396/2005, which regulates maximum residue levels, or MRLs, of pesticides. So essentially those EU regs are being lifted and shifted into national law. HSE will remain the national regulator for the whole of the UK, working on behalf of the UK government and the devolved administrations. So effectively, HSE will continue to do the majority of the regulatory work and the decision making under the new regime. So really, this means that all of the regulatory requirements and technical standards of the EU regime are being carried over unchanged into the national regime. So really, the new regime should look and feel kind of very similar to the current EU one. Just a few quick headlines on the new GB regime. So key change really is that we will take our own decisions on active substance and MRL applications, and any EU decisions that come into force after the end of this year won't apply in Great Britain. You should continue to submit any pesticide applications to HSE in essentially the same format as you currently do, and with the same overall requirements. All of the regulatory requirements of the EU regime are carried over unchanged into the new regime, as is the full body of EU technical guidance that is used to take decisions on applications. So, this means that there's no change in the standards of protection. Also, all existing active substance approvals, plant protection product authorizations, and MRLs will continue to be valid after the 1st of January. PPPs and actives will be valid until their current expiry date, and MRLs until such time as they're amended under the new regime, under the GB regime. We have introduced a transitional provision for active substance approvals, and this means that any approval which is due to expire before December 2023, so that's within the first 3 years of the new regime, will be extended by 3 years. And we've made this change really because applications for renewals need to be made 3 years before the expiry of the existing approval. If we hadn't introduced this transitional provision, that date would already have passed when the national regime comes into force. So really this extension is necessary to ensure that we have an orderly transition to the new regime. But overall, the national regime, the new regime, should look and feel very similar to the EU one, with the key difference being that we will be taking our own decisions rather than being covered by EU decisions. And an inevitable consequence is that there will be some degree of divergence from EU decisions over time. So, for example, this could be simply as a result of taking a decision at a different time, so the GB and the EU regimes being slightly out of sync, or it may mean in some cases taking a different decision on an application. But yeah, you should expect some divergence over time between the two regimes. Okay, arrangements are slightly different for Northern Ireland because, as per the withdrawal agreement and Northern Ireland Protocol, EU PPP regs and MRLs will continue to apply directly in Northern Ireland. So the position there really remains much as it is now during the transition period. Decisions on actives and MRLs that are taken under the EU regime will apply directly in Northern Ireland, but decisions taken under the GB regime will not apply there. But Northern Ireland, of course, will still have responsibility for product authorisations in Northern Ireland under the EU regime, and these will continue to be processed by HSE. Okay, I just wanted to say a few words about the UK Internal Market, or UKIM bill. So this bill is currently going through Parliament, and it has some relevance for PPPs because it introduces a new principle of mutual recognition, which is intended to facilitate the smooth operation of the UK internal market for goods. So this principle of mutual recognition will mean that any good that meets the relevant regulatory requirements relating to its sale in the part of the UK that it was produced in or imported into can be sold in any other part of the UK. Pesticides are classified as highly regulated goods because of the particular risks that they can pose, and because of this, the bill will not apply to product authorisations or active substance approvals. So in effect, each part of the UK will retain responsibility for deciding which pesticide products can be authorised for sale and use in their respective territories, as they do now. Although in practice, we almost always take joint decisions on these sort of applications by agreement. But the position is slightly different for MRLs. So the intention of the bill is that the mutual recognition principle will apply to rules on maximum residue levels in the same way that it applies to rules on goods more generally. And the intention here is to avoid the potential for new internal trade barriers on the sale of food, which has been produced lawfully in the UK, should there be any divergence within the UK in maximum residue levels. And these arrangements will also ensure that any treated produce from Northern Ireland is able to be placed on the market in Great Britain. So, just to sum up, so the mutual recognition principle in the bill will apply to MRLs, but it will not apply to products or actives. One small caveat to be aware of, and that is that EU rules will continue to apply directly in Northern Ireland as per the Northern Ireland Protocol. So treated produce can only be placed on the market in Northern Ireland if it complies with the EU regs. So that's the situation with the UKIM bill. I mean, again, just to reiterate, in practice, all administrations will delegate their pesticide regulatory functions to HSE to undertake on their behalf. So, this should help to ensure a consistent approach to decision making. We also have various structures in place to ensure that we all continue to work very closely together going forward, and we'll continue to take joint decisions wherever we can. All right. So I just wanted to sum up really by just setting out some key actions and considerations that businesses or anyone involved in pesticides should be thinking about in the run-up to January the 1st. So first of all, if you're a pesticide manufacturer or authorization holder, so remember that all current authorizations and approvals remain in place, but you should consider where you want to make your new pesticide applications to in future. So just bear in mind that from the 1st of January, you'll need to make any new applications under both the GB and the EU/Northern Ireland regimes if you want to gain access to both of those markets. If you're a pesticide wholesaler or distributor or trader, be aware that over time there might be divergence in the products which are authorised in Great Britain and Northern Ireland. So this might affect you, for example, if you're a business that regularly moves products between Great Britain and Northern Ireland. If you're a pesticide user or an agronomist who advises on pesticides, remember that there's no immediate change to the products which are authorised. So in the short term, just continue to use only authorised products and always make sure to follow the instructions on the label. But over time, again, there's some extra things that you might need to start thinking about. So if your treated produce is intended for export, for example, to the EU, then you need to make sure that you fully understand the requirements for treated produce in your target market, because this could affect which pesticides you decide to use. And finally, if your business that trades in food produce, just be aware that from the 1st of January, maximum residue levels in Great Britain and the EU/Northern Ireland may start to diverge over time. So again, it's important to think about the requirements in your target market. So, for example, if you're intending to export your goods to the EU, you might want to specify to your suppliers that they meet the EU maximum residue levels. Okay, thank you very much. That's it for me. Thank you for listening. I'll hand over now to Rachel for the next part of the presentation.
Hello, everybody. Good morning. Thanks to Sam there for that part of the presentation. I'm going to start by talking about active substances in a bit more detail, and then move on to products and how they're affected. So on day one, that's the 1st of January 2021, all the existing active substance approvals will continue to be valid in both Great Britain and Northern Ireland. There's no change there at all. We're producing a new statutory active substance register for Great Britain, and this is going to be clearly published on the website from the 1st of January. It'll show which active substances are approved in GB. And for GB, it's going to replace the Commission implementing regulation list that was published under 540 of 2011. So the GB programme for the review of the safety of active substances is still being developed. We are going to retain the power to review active substance approvals at any time, should new evidence identify any concerns to human health or the environment. But as Sam said, we've set ourselves some time to allow the review programme to be embedded and developed. So the new legislation, as Sam said, allows that active substances due to expire within 3 years of the end of the transition programme, they'll be granted a 3-year extension under the GB regime. So specifically, active substances that were due to expire from January 21 to 31st of December 2023, they'll get another 3 years added to their current expiry date. That's a rolling programme, so any actives due to expire in January 21 will now expire in January 24, February 21 to February 24, and so on. Notifications of applications for renewal of those active substances in GB will still be required 3 years before the new expiry date. And we're going to be issuing some more guidance on this very shortly on what's expected there. Just to note, any new decisions on active substances taken under the EU regime, which come into force after the 31st of December 2020, they will not apply in GB. So we've had some questions recently, for example, about the Mancozeb non-renewal regulation that's just been published this week. So that enters into force on the 4th of January 2021, and so that's not going to form part of the retained legislation in GB. It will, however, apply in Northern Ireland. The non-renewal regulation will apply there. In GB, as we've said, the legislation provides that the active substances which were due to expire in that first 3-year period are granted a 3-year extension, and that is what will be applied initially to Mancozeb. It will be extended for 3 years. However, as we've said, we do retain the power to review active substances at any time should evidence identify any concerns to human health and environment. And this may mean that we do take an earlier decision on the expiry date of Mancozeb in the GB as well. Okay, next slide, please. So looking at the active substance review, as I've said, we're still working on that. And we do need to establish a new national renewals programme. But we need to make sure that it maintains effective protection, but is also manageable and proportionate. We need to be efficient in whatever we deliver and not require significant resource in addition to all the other review programmes that are ongoing. So we do have a range of options and considerations available to us. For example, do we look at a high reliance, making use of assessments in other regulators, Or do we take a very low reliance of assessment made by other regulators and do things unilaterally? We could employ a smarter, more targeted approach. And we could look at how we group actives for review. We had certain ideas such as reviewing by classes of chemicals, or perhaps reviewing across legislation, or reviewing by function, such as looking at sugar beet insecticides or blackgrass herbicides and reviewing them in groups. As I said, we've got quite a few ideas on that at the moment, and we will be seeking your views on how such a programme could work. So do please provide us with your feedback on that if you've got input that you want to make to us. We've said that we do plan to use information made by assessments in other jurisdictions. We do make use of assessments in other jurisdictions currently, and this isn't going to change whether relevant and appropriate to GB. But we do need to decide on whether the assessments are suitable for such consideration, and that's going to be done on a case-by-case basis. So at the moment, the GB decisions will at present be made to the same regulatory standards as the EU decisions. And until those requirements change, it's likely that we'll consider those assessments made in those jurisdictions to still be relevant. But applicants can make a case as to why decisions made from any other jurisdiction could be valid. So whilst assessments from other jurisdictions could be used to support an application, we're not going to rely on them. It will be an independent decision made by GB, and while we could use them from information, it still could be a different result or at a different time. So moving on to the application process. How will the product applications process change or stay the same? So on day one, the plant protection product authorisations, previously authorised in the UK, will continue to be valid in GB and NI. We don't need to issue any new product notices at all. All the existing notices will remain unchanged. However, any authorisations issued after the end of the transition period, they will specify clearly whether they are valid in GB, NI only, or in GB and NI. And after the end of the transition period, applicants will require authorisation under both the NI and GB regimes to gain access to both markets. For applications, there'll be no immediate changes to the data requirements or format at all. There'll be some minor changes to the application form itself, and that will be allowed to allow applicants to reflect that applications are required for GB and NI, or in individual locations. And those new forms will be published very shortly on our website. Any applications that we receive before the end of the transition period, they'll be processed in the usual way, although there'll be one or two exceptions, which I'll explain shortly. So the product application process could result in some divergence, as Sam's already said. However, where possible, HSE will maintain a common map number for all the products authorised in GB and NI, where there's no divergence in the conditions of the authorisation. This is to help maintain a streamlined approach and delivery, and we do intend to allow common labelling wherever possible as well. So where there's no divergence, we don't expect to see any changes. However, as Sam said, divergence between GB and NI authorisations may occur in some circumstances. They could be as a result of changes to the expiry date in the active substances, which we've already spoken about, or if GB takes a completely different decision to the EU, or if GB makes a decision at a different time to the EU. So over time, divergence will impact on the conditions of authorisation, data protection periods, map numbers and product authorisations. And we may need to change map numbers of products to reflect that divergence. Okay, that's my summary of products and active substances. I'm going to hand over to Julian now, who's going to talk about MRLs.
Thank you for that, Rachel. Good afternoon, everybody. I'm Julian Cudmore, and I'm the technical lead for MRLs in HSC. So today I moved on the next slide. Thank you. So I'm going to go through the processes for setting MRLs for new MRLs and just briefly touch on the MRL review programme going forward for Great Britain. So as been already mentioned, all EU MRLs, including those that have an application date prior to the 1st of January 2021, will be taken over and become valid GB MRLs. And those MRLs will remain valid until we make a decision to change those MRLs. And any decisions to change the MRLs will be communicated on the HSE website. And particularly if MRLs are lowered, then they will be sent out to stakeholders through the HSE e-bulletin centre. And those decisions will be made on our own decisions going forward. All applications to support a new MRL can be submitted to HSE in exactly the same format as they would have been previously when you wanted HSE to take forward the evaluation of an EU MRL. And it's just important to note that all the data that is required to support an MRL, the tox and residues data, will remain going forward. And that's also the same for import tolerances. Next slide, please. So there will be some Pacific GB documentation that is made available on our website from the 1st of January, and that will be a Pacific GB MRL application form. We will also have our own version of the evaluation report that stakeholders are expected to fill in when they submit an MRL application form to us, but they are very similar to the EU documents that are currently available that people will be used to using. Typically, evaluations for MRLs take around 12 months, and that includes MRLs for new product authorizations and import tolerances. We also then give an additional 6 months if we need to request any additional information. The important point to note is that where an MRL is linked to a product authorization, and that includes a temporary MRL for an emergency authorization, the MRL decision and the implementation of that MRL will occur at the same time as the decision of the authorization. So there won't be any waiting for an MRL to come into force so that the plant protection authorization can be granted. Next slide, please. Thank you. Under the current system, EFSA takes responsibility for publishing their reasoned opinion on their website, and also they publish the member states' evaluation report as a background document. Going forward, HSE will publish all our assessments on our website. Along with an evaluation report and reasoned opinion, we will also publish a decisions document, and that acts as a link between the assessment outlined in the evaluation report, so the risk assessment, and then also the final decision on the MRL. The decision document will also outline any important information on transitional measures, deferred entry periods, or any data gaps that are associated with the MRL. Going forward, when we establish new MRLs, those MRLs will be implemented by means of inclusion in a statutory register. So there won't actually be any separate implementation regulations as there are in the EU or any statutory instruments. They will just simply put in the register. And the MRL register is essentially an updated version of the UK MRL database that is already available on the HSE website. So if we leave new MRLs behind and we just look at the MRL review programme, while we were a member state and also during the transition period, there would have been a lot of decisions on the EU MRLs. And so there may be some MRLs that have data gaps associated with them. So MRL confirmatory data or supplementary information. If the decision on those outstanding data gaps for the MRLs hasn't been delivered prior to the 1st of January 2021, then those data gaps will be retained and they will be copied over to the GB MRL. So the information and data to address those outstanding MRL confirmatory data should be submitted to HSE so we can undertake our own assessment of that data. In the first few years, we won't have a formal MRL review programme, so that will be established within 3 years of the end of the transition period, and it will follow on from the active renewal programme that was mentioned. However, during the time before the end of the transition period and before we establish the formal MRL review programme, we may review MRLs periodically, particularly if information comes to light from other jurisdictions or international organisations such as the Codex Committee on Pesticide Residues, and we will initiate those MRL reviews, particularly in the interest of ensuring that UK consumers are protected. Next slide, please. So thank you for listening to the presentations on the plant protection product regime. I just leave you there with a few important contact numbers and email addresses for the plant protection product regime. And I believe we're handing back to Matt now.
Thank you, Julian, Sam and Rachel. We thought we'd give a little bit more time to PPPs than the other regimes, just because of, as you've appreciated, the range of issues there, particularly with regards the UKIM, the internal market bill that Sam talked us through. So we'll have a bit less time for questions, but let's pick out some important ones. And I think there's been a couple of questions back to you, Rachel. He covered Mancozeb, so a couple of colleagues. So Philip from Greenville has just asked to re-emphasise the issue about Mancozeb. So it's non-renewal from 4th of January 2021. What does that mean for GB in Northern Ireland?
Yeah, this is a really good live example that's just come to us this week, really. So the non-renewal decision has been published by the EU for Mancozeb, but that only comes into force in the EU legislation on the 4th of January. And it's that coming into force date that's really important. So it comes into force on the 4th of January, which is after the end of the transition period. So it's not automatically becoming part of the GB retained legislation. However, it does apply in Northern Ireland. So we will be taking action on products containing Mancozeb for use in Northern Ireland. What the regulation allows us to do for Great Britain is that we could extend Mancozeb by a further 3 years as it expires within that 3-year period that we talked about. And that's initially what we'll probably do. However, as we've also said, there is scope to review earlier should we have any concerns. So that might be something that we need to do.
Thank you, Rachel. I'm going to jump back to Julian, if I may. And just there's a few import MRLs, Julian. So this one's from Aline from Brian Christie, and this is around import tolerances and the use of the EU IT processes. So will interested parties be able to request import tolerances following the EU IT process? If it's not for you, Julian, I apologise in advance. I thought it might be for you.
No, Matt, that's perfectly fine. That is for me, I think. So, yeah, the process that we follow for import tolerances will be very similar to the process in the EU as it operates now. So you just need to submit the application to HSE with the standard HSE email address, fill in the evaluation report as you would already for a member state, and then we can assess that. And as I said, the standard processing times are 12 months to do that assessment, and then 6 months would be given for any additional information that we need to request.
Brilliant. Thank you, Julian. And I'm just jumping about a bit. Rachel, I don't know whether you covered EAMUs, but there's a question from Gary Bradbury Consultancy about, do we see any changes in the way that applications for EAMUs are going to be managed, given their essential use for minor crops?
Yeah, we do really recognise the importance for growers of the EMU system. The regulation doesn't change at all, so we don't really anticipate any change to the EMU process. That we'll carry on accepting and processing applications as we do now.
Brilliant, thank you. Let's see if we can rattle through a few more. Is it, Rachel, I don't know if this is you about dual labelling. There's a question from Jennifer from SBM around how could dual labelling for PPPs work after the end of the transition period in GB, Northern Ireland, and also Ireland, so I guess on the island of Ireland.
Yeah, so with regards GB and Northern Ireland, where there's no divergence at all in the products initially, there isn't going to be very much. We envisage common map number, common product identity, and a common label. However, if there is divergence over time, for example, there are different conditions of use between GB and Northern Ireland, then that may require different label requirements and different map numbers. We do have, obviously, an agreement with the Republic of Ireland regards dual labelling, and that's something that we'd like to continue if we can, but we do need to talk to the Republic of Ireland about that and make sure that we have agreement going forward. But it is something that we recognise is really valuable and important, and we'd like to carry on with that.
Brilliant. If I can just bear with me for one more question for you, Rachel. And this, again, it relates to Northern Ireland. It's from Steve from Solvay, and this is around active substances. If it's manufactured and used only in Northern Ireland, who will evaluate my dossier?
So if it's an NI, so I'm looking at the question. I haven't read that one. If it's an NI only
yes,
active substance.
Yes.
For PPPs?
Yeah, for PPPs.
Yeah, that would need to be an EU evaluation to appear on the EU active substance register as opposed to the GB active substance register. So if it was purely an evaluation for Northern Ireland, that would need to go through the EU system. But obviously, Northern Ireland doesn't have member state status as such, so the active substance would be going through the EU system through some other means rather than through Northern Ireland, I would imagine.
Okay. Apologies for putting you on the spot. That and just came in just as you were on. But again, we can go back and make sure that the guidance is clear. And I think that's the commitment that we're going to give, is the look at the questions, because actually a lot of the questions have got similar themes. We can make sure that, if there's obviously any gaps in our guidance, we can address that and we can do that. So I'm going to bring this session to a close just to keep us on time. I know there are more questions that we've been able to answer, but like the other regimes. But if I just thank Sam, Rachel and Julian, and again encourage colleagues on the call to use the information that Julian highlighted in the last slide, and to contact us if you need to. And obviously on that, there's the pesticides and detergents helpline that is still there. So thank you to Rachel, Sam and Julian.